Hello, this is the lecture series for Ethics in the Legal Environment, and I'm the instructor for the course, Roun McNeal. I recently bought a new car, and this is my first car with collision assist. It has a network of sensors connected to a computer that will activate the brakes if the sensors detect that the car is about to collide with something else. These bells and whistles and gadgets on cars are great until they malfunction. The day the collision assist malfunctions, the driver finds himself wishing his car was about as sophisticated as a Ford Model T and will begin cursing the day that computers were even invented. Were it me, and the collision assist malfunction causing my car to think that it is about to collide with something and keep the brakes constantly engaged, I would call an expert, a mechanic. And I'd ask, given his or her experience and knowledge, what is the best way to deal with this situation? I'd tell the mechanic my goal to be able to get mobile again while doing the least amount of damage possible to my car, and I'd expect a competent answer. Keep this situation in mind as we turn from automotive professionals to legal professionals. Well, this is the first lecture in the unit of this course that deals with maintaining competency, diligence, and communication in a law office. In these lectures, we will get our first glimpse into what constitutes legal malpractice. But first, I want to talk about competency and one of its core requirements, rendering independent legal judgment. But what exactly is independent legal judgment? The first thing you need to know is that clients don't always know what is best for them. That's a harsh way of putting it, but it is true that sometimes clients want to proceed with a strategic course that you, as a lawyer, know from training and experience is either too risky or destined to fail. But there is a tension, because in any legal matter, the client is the principal. That's a phrase you'll need to remember. The client acts as the principal. What does that mean? Well, it means that the client sets the objectives or goals of the representation. The objective in a divorce claim may be just to no longer be married to the other person, or the objective may be to have custody of the children, or it may be to pay as little alimony as possible, or it could be a combination of the three. It isn't the lawyer's job to substitute her own judgment and tell the client, kids are the most important thing in life, so in your divorce, we will negotiate everything and anything so that you can have custody of the kids. That may not be what the client wants. The client's job is to set the objectives or goals of the representation. That's what it means to be the principal. The attorney's job, on the other hand, is to develop, suggest, and implement methods of achieving the client's goals. In doing so, attorneys have to exercise independent legal judgment. Sometimes there is a conflict between the client's objectives and the attorney's independent legal judgment. For example, what if the client's objectives or methods are unethical? Let's say that during a divorce trial that has not been going well, the client brings you an allegation for the first time on day 3 of that trial that her soon-to-be ex-husband has been physically abusive to her and to the children. She's never said he was abusive before, and you strongly suspect that she is lying because she also recognizes that the trial is going poorly. You now have a conflict between the client as principal, who wants to testify falsely about abuse in order to get an advantage in the trial, and your independent legal judgment, which includes a duty of truthfulness, a duty that we will cover later. You may be forced to present the client with the uncomfortable truth that you suspect she is lying. You are not ethically permitted to suborn perjury, and strategically, the judge might be suspicious of this late accusation of abuse, and the whole thing could backfire. This is the exercise of independent legal judgment. Now is as good a time to point out a difference between attorneys and paralegals. Some people who are listening to these lectures are planning to go to law school. Others are planning to be in a support staff role like a paralegal. Because the training, authority, and obligations of lawyers and paralegals are different, Paralegals do not generally exercise independent legal judgment with the client. Rendering legal conclusions or opinions directly to the client could be seen as the unauthorized practice of law. Imagine a hypothetical in which the same divorce client above calls the law office and asks a paralegal in the law office to give her advice on whether it would be helpful in the trial to reveal her allegations of abuse on the stand. The paralegal may well know exactly the types of concerns her lawyers might have in this situation. She might even think that it will save everyone time, money, and effort if she conveys her concerns, the same concerns she believes her attorney would have, directly to the client. But the paralegal does not have the same training as a lawyer. Let's say that I call the mechanic to ask about my brakes engaging because of the collision assist, and let's say that an overeager receptionist tells me, just keep driving. I'm sure it will be fine. When my brake pads have been ground down to dust and my rims have ruts in them, I will be displeased with the advice that I have gotten. In the same way that the paralegal is less trained than a lawyer, a paralegal does not have the same kind of professional liability as a lawyer. As we will see when covering malpractice, if a lawyer negligently messes up a client's case and causes them injury or damages, there are legal remedies to make the client whole. Paralegals do not have the same level of duty and are not as likely to be held liable for their negligence. So it needs to be a licensed attorney with all the experience, training, and potential liability who advises the client. The role of a paralegal is to render an opinion to her supervising attorney. Every day in law offices all across the country, paralegals are analyzing facts, researching law, and rendering legal opinions, but they do the work under the supervision of a licensed attorney and render work product to the supervising attorney, who is ultimately responsible for the quality of the work. Having a foundation for what the different roles paralegals and lawyers play, let's return to the relationship between the attorney and the client. Recall that the client is the principal and sets the end goals or objectives of the representation. This relationship is analogous to that of a car owner and a mechanic. The client owns the matter and consults with the attorney about the best way to fix it, much like a car owner decides what he wants the objective of a visit to the mechanic to be. For example, I want the air conditioner to run, or I hear a squeaking whenever I hit the brakes. But the car owner does not know how to fix the problem. He doesn't have the training to determine what methods will achieve the objective. Only the mechanic can do that. As I began to reference earlier, the client may choose an outcome or objective that the lawyer disagrees with. In criminal contexts, there are three specific outcome determinative decisions that are always left to the client that are illustrative of this principle of client as principal. Clients always have authority to determine whether to waive a jury trial, whether to enter a plea agreement, or whether or not to testify. In each of these three scenarios, the lawyer may think or even know that the client is acting against his own self-interest, but the client, as principal, gets to decide. There's a glaring exception to the rule of client as principal, and that is where the client instructs the lawyer to engage in misconduct. The client cannot engage his lawyer to break the law or the rules of ethics. If the client's objective is an illegal or unethical one, the attorney is bound to either not take the case or to seek to withdraw from misrepresentation. Related to independent legal judgment is the attorney's duty of competency. Throughout this course, we will discuss several ethical duties which are imposed upon licensed attorneys, and we will discuss how licensed attorneys are obligated to make sure that their staffs also rise to these duties. It is important for students to remember these duties by name, be able to either remember or find the rule number associated with those duties, and to explain what kinds of behavior the rules require or prohibit. The duty of competency simply means that the lawyer possesses the ability to perform legal tasks with the skill and knowledge in the relevant field that are required to obtain a satisfactory result. The duty of competency is implicated in a few areas: specialization, experience, and staff. Specialization refers to a few highly specialized areas of law practice that often require more education and training than just a law degree. We might specialize in tax law, intellectual property, or admiralty. In any of these areas of law, one can obtain an advanced degree or educational certificate that is beyond a law degree. Many programs call these advanced degrees Masters of Law, or LLMs. While it might not be strictly required in the jurisdiction to obtain this type of degree in order to practice, say, tax law, it is absolutely necessary to obtain some additional training. A lawyer violates his duty of competency if he holds himself out to be capable of handling a complicated tax matter when he has not received training on the subject. The same might be true of environmental law or space law. The point is that some areas of law are so unique and specialized that just passing law school and the bar are not enough training to be competent. Other, less specialized but still highly complex areas of the law might require a certain amount of experience before lawyers can competently handle such cases. Medical malpractice cases, real estate transactions, and product liability are a few examples of practice areas that, without some experience, lawyers should be hesitant to assume that they are competent. The third implication when talking about the duty of competency is the competency of the lawyer's staff. Ultimately, the lawyer is responsible for all the work product that goes out the door. If a pleading, contract, or production of documents is messed up in some way that damages the client or a third party, the lawyer and not his staff will bear the personal and professional liability for that mistake. So the duty of competency includes making sure that the staff of the law office is competent themselves to perform the tasks assigned to them by the supervising attorney. Another component of competency is the lawyer's duty to keep herself updated about new issues and changes in the law. Law isn't static. Every week, the Supreme Court of Mississippi releases new judicial opinions. The Supreme Court of the United States hands down several opinions each week while it is in term. Most states require attorneys to engage in continuing education programs, usually a few seminars each year, and calls this continuing legal education. Attorneys who fail to obtain the required number of hours of continuing education may have their license suspended until they do. Continuing education can have a particular focus on changing technology. Lawyers use technology for research, communication, and preparation. Technology, especially in an informationally connected age, is not always secure, so particularly the duty of confidentiality can be compromised. If this all gives you some anxiety because it is difficult or impossible to know everything about the law, or even everything about a specific area of the law, take heart. The duty of a lawyer is to be reasonably knowledgeable about relevant legal issues. This is where the duty of competence can look more like practical action than an obscure standard, because an important skill in the legal profession is knowing how to find the answer. Lawyers constantly have questions about discrete legal issues. They use legal research tools to examine judicial opinions, guidance from executive officers or administrative boards, and statutes and regulations. So when faced with a legal issue that is unfamiliar to the lawyer, the duty of competency demands that she know how to find the relevant law using legal research methods. Let's take everything we've learned about the duty of competence so far and apply it to the specific rule of ethics in Mississippi that relates to this duty. In Mississippi, the rules of ethics are called the Mississippi Rules of Professional Conduct, and the standard for the duty of competence is found in Rule 1.1, which says, "Competent representation requires the skill reasonably necessary for the representation." Let's unpack that. Skill involves knowing, analyzing, and applying laws, as well as crafting arguments and preparing documents necessary for the representation. It further involves knowing how to strategize for the best result, including possibly a negotiated compromise. In support of attorneys and under their supervision, understanding that the final product is the responsibility of the lawyer, paralegals might supplement the lawyer's competencies by performing legal research, drafting preliminary documents for the lawyer's review, summarizing information, identifying material facts after, for example, a client interview. They can handle procedures in the office and with courts, they can be organized, and they can manage multiple tasks efficiently. Lawyers and paralegals are responsible for ascertaining appropriate delegation of work. They must know each other's limitations. A paralegal who recognizes that her supervising attorney is a disorganized mess will be an invaluable part of the office. A supervising lawyer who fails to recognize that her paralegal is prone to misunderstanding or misapplying legal research to the facts of the case will ultimately produce faulty work product and possibly violate her duty of competence. A final element of the duty of competence is thoroughness and preparation. If, as an undergraduate, you're anything like I was, you're prone to making silly mistakes. You rush through finishing a paper and leave it with typographical errors. You forget about a meeting or an assignment because you do not keep a good calendar. You don't have time to double-check your math, so you hope it's right. This is unadvisable behavior in your academic career, but it's just your academic career. As a legal professional, you're holding someone's life, or at least a very important aspect of it, in your hands. You're accountable to that person, so the care you put into the preparation of that person's case is a big deal. An example of this lack of thoroughness and preparation is found in the case Henry Shepperson. Shepperson is a Vermont case in which a lawyer, Carlisle Shepperson, was suspended from the practice of law after submitting appellate briefs in his client's cases that were, quote, generally incomprehensible. The Bar Association suggested that Shepperson complete some remedial legal education courses, which Shepperson flatly declined, claiming that his remediation violated his freedoms of speech and religion by dictating what is and is not proper legal argument. As you can imagine, Mr. Shepperson's license was suspended until such time as he could demonstrate an ability to compose legal writing that just made sense. Take a moment to think about the consequences for Mr. Shepperson's clients. Perhaps he does have a right to his own arguments and opinions, but if his inability to render logical arguments causes harm to the interests of his clients, then he is not deserving of the privilege of a law license. The next lecture will continue this unit on competence, diligence, and communication. In review, this idea of competence and the attorney's related role of exercising independent legal judgment means that an attorney must put in the work to do the job well. Most lawyers cannot cite a case from memory for every principle of law under the sun, so competence requires work. Whether working to develop that specialized skill that's required of niche lawyers like bankruptcy, admiralty, working to stay abreast of developing technology or legal principles, or working in preparation to ensure thoroughness, competence is a standard of work, just as much or more than it is a standard of achievement. A lawyer certainly cannot take on a case hoping that he will develop the skills and knowledge required to represent his client, but also, when faced with the question about whether or not he violated the duty of competence, a lawyer's best answer is to be able to say that he put in a reasonable amount of work on being competent. Work is also implicated in the duties of diligence and communication, and that's what we'll cover in the next lecture. Until next time.